Hello, law students. This is Mrs. Politsky, and I have your notes for Chapter 1, Section 2, Types of Law. So, sources of law, there are some different ones. First, there's the Constitution. This is where we start seeing things like allocation of power, such as between people in the government, between the federal government and state governments, and this also breaks down between the different branches of government. We can also look at statutes. Statutes are, for the most part, laws enacted either by a state or federal legislature. Along with that, you have case law, and case law is created by the judicial branch. You might hear things like stare decisis, which is getting into this whole concept of precedents or talking a little bit about what has happened at previous times with different cases that sound very similar. And along with that, you might hear about administrative law, which is talking about the law of administrative agencies. So, an example would be like for the IRS and talking about like taxes and tax evasion and things like that. What happens when laws come in conflict? We're going to talk about the Constitution and the validity and statutes and validity and such. So, the Constitution and validity, the U.S. Constitution is always going to be the highest law of the land. So, if there is something that happens at a lower level, it's always going to be the U.S. Constitution, if it's called into play, that is going to take the upper hand as far as how the court would decide a certain case. When you talk about statutes and validity, statutes and ordinances, they have to be constitutional to be valid. So if a state enacts a law or a city enacts a law that, for the most part, is in direct violation of U.S. Constitution, the statute or the ordinance is going to be considered to be invalid. And again, your U.S. Constitution is going to be the highest law of the land. So courts would determine the validity of the statute and the ordinance by hearing a case before the courts, and how the court would rule would probably reflect maybe the validity of that law or ordinance. Letter C, the administrative regulations and validity. For the most part, when we talk about regulations that come from our government agencies and that, they have to be reviewed by the courts to determine, again, if they're constitutional. And then finally, case law and validity. Courts are not always the final authority in some cases. People have the power to amend their constitution. They may be able to contact their lawmakers, maybe to write legislation, or perhaps maybe even to, again, call for like a constitutional convention to amend that constitution to change the interpretation. What are the main types of law? There's criminal and civil law to start with. Civil law is basically laws that deal with private wrongs. Sometimes civil law is also known as tort law. Then there's criminal law. These are wrongs that are against society. When a person is named in a criminal case, typically it's usually going to be that person's name versus either the state or the U.S. government. Procedural and substantive law. Procedural law deals with the methods of enforcing legal rights and duties. It could be things like how you're going to conduct some kind of legal action. Did you follow certain procedures as far as how you filed charges, or allowing maybe somebody who is a defendant to have access to an attorney? Are you using probable cause to kind of determine whether or not we have a case? All this is kind of reflecting back to some things that happen with Roman civil law. The other is substantive law, and this is defining rights and duties. This could also be talking a little bit about the substance of the nature of the case. So this is concerned with the rules of conduct. It might get into talking a little bit about things like the degree of murder, like if we're going to accuse someone of murder, how do we define what is murder or theft or negligence? And along with that, there are certain criteria that has to be followed. You have to prove anytime that you're talking about the substantive side of things, that something is beyond a reasonable doubt, to establish, a certain form of justice here. You're going to use jurisdictions. You're going to understand, or at least make sure everybody understands the elements of, the nature of either the crime or, in this case, like negligence, the civil wrong. Business law. This is any kind of law that applies to the rules of how business takes place. So the rules that apply to business situations. One of the earlier parts of this is the Uniform Commercial Code. This was established back in 1952. And what it was meant to do was to kind of at least establish laws for sale or laws for commercial transactions. And a lot of it talked about things that are like personal property. These would be things that you could move. So it could be talking about the buying of an item and how it's going to be bought and sold, to things that are not real property. These are the non-movable things. So we could be talking about things like intellectual properties, like the rights to a certain procedure or a design or something of that nature. This establishes, certain rules for sales and leases and banking, even securities, auctions, or how you even liquidate, maybe a business. The final thing is the torts. And I mentioned before, tort law is like civil law. That's mentioned above. This is dealing with private wrongs. Typically, if there's going to be a tort, it's going to be your name versus another person. It could be for people who have suffered some kind of loss, meaning financially. It could also be because someone has been harmed. So, I bought a product and it, malfunctioned and hurt me. That would be an establishment of tort law opposed to criminal law. So what determines whether a particular law, statute, ordinance, or regulation is valid? And that would be whether or not the federal Constitution, which is the supreme authority, the highest law of the land, the validity of the law is determined by whether they violated the Constitution. And then how can a single act violate more than just one kind of law, such as being both civil and criminal? Which, by the way, there are a lot of cases that are like that. Civil laws govern offenses against individuals, while criminal law addresses violations against society. It could be such a thing that one act hits both sides. So you could have an individual involved in a murder case, but because of the fact that they might have damaged property, or there was maybe a financial loss involved because of the death of someone, that a person might have the ability to sue based on the grounds of a criminal issue and a civil issue. Thank you very much.